Says her probation officer told her she had a month.
I told you here what you were supposed to do. I'm tired of playing this game.
This is not just another routine court update. This is a judge at the end of her patience. We're about to watch a legal tug-of-war where one side is running out of excuses, and the other is running out of mercy. The defendant, Carol Ramirez, is under strict probation terms, and the clock has been ticking. For weeks, she's been told to take very specific steps, and yet, here we are again. As you listen, ask yourself, is this willful defiance, or just someone completely in over her head? Because in a courtroom, that distinction can decide your fate.
We're set for an update today. She does have her ankle monitor on. She's registered with IOP. She has orientation tomorrow, and she starts Saturday.
Okay. Was there anything else that was supposed to happen?
I'm sorry?
She was supposed to be finished with SOP and now registering for IOP, right? Wasn't that
No,
what?
she had to start. It's IOP first and then SOP. So she has to do IOP.
Weeks ago.
No. We were here
It was not
too long ago. She's the one, Judge. I don't know if you remember
No,
that.
I remember everything. Yeah.
Okay.
So I have here on 9/13, this is when we amended the agreement to do the 3 days and then scram upon release and do IOP and SOP. That was 9/13.
Yes, and you told her by the time she comes back, she has to be registered, which she is. She has orientation on Thursday and she's starting on Saturday. That's what I have.
Shatori, we're talking about Carol Ramirez.
Just talked to her. She had a visit with her officer, and at that point, she wasn't registered. She just sent me over the company she registered with. So I'm gonna call them. And
She's still pushing it. Still pushing it. I mean,
she goes on Thursday.
same thing. It's over and over. It's come up, Miss Ramirez. I don't understand why you are still pushing your luck. You were supposed to register immediately upon doing the 3 days as a condition. When did she do the 3 days, please?
September 20th is when she went in. And that Monday, I think you reinstated her, Judge.
Yes, Judge, it was September 20th.
She did. She was released on when, the 21st.
On the 23rd. 23rd is when she was released.
Released the 23rd. She was supposed to register.
Carol's probation officer allegedly told her she had a month, but the judge is clear, she was supposed to register immediately. This is a classic courtroom problem, conflicting instructions. But here's the truth, in legal supervision, when in doubt, you follow the most restrictive order. Immediate registration means there's no window for backsliding, no temptation to wait until later. The fact that she registered just yesterday suggests either procrastination or a gamble that the court wouldn't check. And in a probation context, gambling like that almost never pays off.
Immediately starting the IOP. And what day did she register?
Yesterday.
Says her probation officer told her she had a month.
I told you here what you were supposed to do. I'm tired of playing this game, Andrea.
At least she's registered.
It's like, you know, when this is what happens when you're too nice.
The judge's comment here, this is what happens when you're too nice, should make every defendant's ears burn. Court leniency is a privilege, not a right. And when leniency is met with delay, it turns generosity into resentment. The subtext here is powerful. This judge feels her goodwill has been exploited. In probation law, that emotional shift can change everything. A judge who feels taken advantage of is far less likely to approve future accommodations. This isn't just about paperwork, it's about credibility, and Carol's is vanishing fast.
It's over and over. People take advantage of you like crazy. It took 1, 2, 3, 4 weeks for her to sign up for IOP, Andrea. 4 weeks.
Can you, since she's already registered,
No, I mean, I'm done with this. I'm just, what,
let her see if she goes, if she attends? I don't have I don't, there's not much that I can say. I don't have much to stand on.
she
But
doesn't take us seriously.
I'm hoping that you will allow, since she's already registered, you'll allow
Let's
her,
do this. Let's do this.
because she has an ankle monitor on. That's on. It's
I'm
on
gonna
there.
send her for a drug test right now. I want to see what if anything that she's gonna test positive for. And then right now, I want to send her for a test. And then I guess we'll talk when she comes back. Because first things first, I want to know if she's clean. If she's not clean, it's over. That's it.
Notice how quickly the judge pivots. Send her for a drug test right now. This is not random. When compliance is in question, judges often look for other possible violations. A failed drug test can short-circuit the entire discussion and lead directly to termination from the program. For the audience, imagine being Carol. You walked into court thinking you'd talk about scheduling. Now, within minutes, your sobriety is on trial. And if that test comes back positive, the conversation about leniency ends instantly.
But if she's clean, then we'll talk about how we go further.
Did I
But-
send her back here?
Yeah.
How long, so I know how to manage everything else that
I
I
have
have.
your cell phone, right?
Yes,
I'll text you when she comes back
okay.
and I don't know. Just take a seat for a minute.
Thank you, Judge.
Thanks, Andrew. We're talking about Carol Ramirez.
Here, this is not good news for me.
Let me tell you at the outset that I'm very upset, disappointed with the way that she's handled things. And
She being the
the defendant.
alleged, yes, Judge?
So she was extended on PTI.
What happened was she gets into a DWI PTI program. While she's in the program, she basically just continues to party,
The
essentially.
prosecutor brings up a damning detail. Carol was in a DUI diversion program but continued to party, testing positive for alcohol and marijuana. This isn't just a rule breach, it's a narrative problem. It suggests she doesn't take the underlying offense seriously. Courts see this as a threat to public safety, not just a personal failing. And the excuse, celebrating her sister's birthday, might sound innocent outside court, but in here, it reads as willful disregard for probation terms. When you're in a program meant to rebuild trust, even one bad night can unravel months of progress.
Essentially. I think she's using marijuana, she's using alcohol, she blows positive on the devices.
What I remember, Judge, and I could be wrong, but what I remember is that there was one positive for alcohol. I'm gonna pull up the email.
No, there's definitely, there's more. There's more than that.
She had some positive tests on her device, and then the probation officer asked her about it. She said she had about 10 years celebrating her sister's birthday.
That's the positive that I know,
How
but
many
it just took a
positive?
long time. But it was the same day, the same, right? I'm sorry, Judge, I didn't mean to interrupt you.
It's okay.
It looks like it was only for one actual positive violation on July 21st.
That's the entire time? And you said, did she have a device the whole time or no?
She did have a device the whole time.
Okay.
She's on a scram and an in-car right now.
Now she is.
Yes, yes.
She didn't have that before.
No.
Well, it doesn't seem like PTI is going too well for the young lady, Judge. I don't see the bond violation report. I don't know if I have access
No, it
to them or
wasn't.
not.
No, they
It's
weren't.
not, because she's in the PTI program, we're not going to get the traditional bond violation that you would normally get with the email and everything. They just do the BVRs through here. And then what happens is they bring them back to court here. And then we typically admonish them, have some kind of agreement going forward or whatnot. So the idea was this, is that we amended the agreement. She was to do 3 days as a condition.
She did.
Right, she did. And then she was immediately going to apply for the IOP and SOP, and then she'd be out of the program, right? And complete it successfully. 4 weeks later, she just now signed up for the IOP. Was it yesterday?
Yes, sir.
When she was supposed to do it 4 weeks ago, right? And she was supposed,
But she did get her scram device, Judge. She went and she got her scram device, which costs a lot of money. She had that done. It's on her ankle. I'm not trying to justify her not complying with the IOP SOP.
here's my next issue. One of the positives, we sent her for a drug test. Now she's negative. My issue now is that
The IOP is gonna take 4 months, and then the SOP is gonna take an additional 3 months.
it's not supposed to
The
be like
SOP
that.
is 30 days.
I just
Right.
talked to the provider, this is a pay-as-you-go type of SOP, IOP SOP she has selected, and they do classes once a week.
And it's not supposed to be like that. IOP, it's designed to be 3 times a week because that's what makes it intensive, right? The intensive portion of it and the spirit of doing IOP is that it's done 3 times a week in rapid succession. And it's done like that for like a month or a month and a half. And
Here's where the judge's frustration deepens. Carol signed up for an intensive outpatient program that meets once a week. That's like signing up for a marathon and only running 1 mile. The whole point of intensive treatment is frequency and consistency, typically 3 times a week. Whether Carol misunderstood or deliberately chose the easiest option, the result is the same. It undermines the spirit of the program. In legal terms, substantial compliance isn't enough when the condition is clear. And in the judge's eyes, this is not compliance, it's evasion.
that's why it's intensive. So she signed up for a class that's 1 time a week for 4 months.
Judge, to her defense, she was given a list, and I'm like, no, I don't want to offend anybody.
You're not, we have thick skin. You're not going to offend anyone.
She was given a list and she was told, call from this list and schedule. So I don't remember if she was told that she had to pick one with the 3 times a week. I'm not aware of. I know that IOP is 90 days and I know that she has to go multiple times a week, but I don't remember her being told that she needs to pick one, which is, I'm not trying to excuse, nothing I can say changes the fact that she registered the day before court. But I don't remember her being told that she has to pick this one.
She gets TRAS and then they tell you.
I don't know any, I'm not present for those. So that's what I'm saying. I don't remember anything. I don't know if she was admonished by her regular probation officer or if you.
Bottom line, Andrea, this is not going to work. It defeats the entire spirit of doing IOP because that's even at a slower pace than what SOP would be. SOP does even more so than what this.
Well, Judge, so she spent a lot of money getting that ankle monitor on. They're super expensive. I'm hoping that, and again, I have nothing to say to the fact that she waited until yesterday, but she did register. She set for orientation. If she swaps to a place that does it, so she does orientation, she starts, and we bring her back in 2 weeks, already registered, already orientation done on a place that does it 3 times a week. I would hate for her to be on the whole, hundreds of dollars for getting the ankle monitor on, thinking that she's going to continue on the PTI.
The problem is that I can't trust her to take the scram off, right?
But she's never done anything to temper with anything. She's never not comply when she had the interlock on.
She's all the time failed to comply, all the time.
She's had one positive for alcohol, but in terms of the device, because you said my understanding is that you have concerns that she would tamper with the ankle monitor, right? Is that what you're saying, or am I understanding you wrong?
I have concerns that she would use.
Well, then leave the ankle monitor on. It's costing her a lot of money to have the ankle monitor on and the.
One sympathetic point emerges: ankle monitors, in-car devices, and treatment programs are expensive, sometimes prohibitively so. The defense leans on this, suggesting financial strain is slowing compliance. But here's the tension: the court's role isn't to manage someone's finances, it's to ensure public safety and uphold the law. If Carol truly can't afford compliance, she should have sought a formal modification earlier. Instead, the delay makes it look like an excuse, not a reason. Judges here, I couldn't afford it often, but only trust it when paired with documented efforts to solve the problem.
And the in-car, and these classes are not cheap. So it's a lot, it's costing
And
a
Andrea,
lot.
normally, I mean, I would pay for it if I could.
I know, and we tried.
Tried.
Right, and I emailed Beetle, and it's not something that they do, and I understand that if they do it for her, then where do we draw the line? So we tried, but she's at a
I'm
point.
trying to tell you.
I'm sorry.
No, it's okay.
And it's okay. And I'll give
Ultimately, it's your decision. We can talk
Well,
about all we
No,
want.
no,
Mr. Lindsay, I'll give.
please allow.
What I'm trying to tell you now is that in the current state of things, IOP being one time a week, it's not acceptable. And I'm not prepared to do a reset for one time a week as IOP.
Well, then let's change it. Let's bring her back in a week or two. And at that point, Judge, if she's not registered where she has to be, then I'm not even gonna open my mouth. I'm gonna shut up and I'm not gonna say anything.
What do you have to say? Because
This case originally filed in 2022. This case lingered. It seems to me that the case went on for a little while before she actually entered PTI. Prior to going in PTI, it seemed like she had some issues with the court.
What issue?
Well, there was something in here, I think she had a medical issue with strep, so she didn't appear.
Right, she was
There's-
sick, but
There was some bond I don't know if there was or not, but it looked like she was set for bond forfeiture on one day previous. Out of this court, I don't know resulting, but the bottom line is now, since entering PTI, it seems that there are still being continued issues. And now here we are.
what issue? She only tested positive for alcohol once.
She got a scram device.
Yes. So she has it. That's the thing. Like judge ordered her to, she went to jail for 3 days. She was in jail for 3 days when we amended the conditions for the PTIs. And then when she came out, judge said she wants her to have both the scram and the in-car. So now she has both devices.
did she ever have any bond violations while she was on bond?
I would hate for her to get kicked out with all the money.
243
She's not-
0612.
I'm not trying to say
Yeah,
she
I know.
is, but the problem is,
I know.
this is
I know.
November, almost November 2024.
I get where you and
Like-
judge is coming from. I'm just,
Let me ask you, do you think it's in our best interest to continue?
she
I'll
spent
tell
all
you
this money to get
guys,
income on her own. I'm sorry.
Well, no, I'm not.
Mr. Lindsay, I don't know if we're going to go forward, but if we do, I'm literally going to bring her back on a bi-weekly basis to make sure that she's in compliance. I'm not going to sit here and just continue to spoon feed this thing every 4 months to make sure it gets done. I mean, every 4 weeks, I'm not doing it.
I agree with you, Judge. I'd like to reach out to the manager of the program to make a recommendation to that individual and go from there. My personal thoughts are that this is a very old case. This case has had issues and has continued to have issues. The purpose of this program are for individuals to get their life back together. If that's not going to happen, then I think it just does the alleged defendant a disservice to keep her on a program that she's not going to make. To be my personal, it doesn't do the court any justice. It drains her of money, right? Financially, it keeps her on a docket for the court to belabor and continue to supervise. So that'd be my position, is that we probably terminate PTI, reset the case, set up a trial, or work it out. But that is not up to me. I'd like to highlight to the court.
But no, but it is. It's your program. It's not mine.
When I said me, I didn't mean the state of Texas judge. I meant me as like the individual George Lindsay. I'd like to, if I could take a leave of the court for 20 minutes, make a phone call,
I mean, there's
and
no,
see where we stand on this, Judge. If the court allow me a motion to leave.
Can I run to another court and come back? Or are you guys almost done with docket, or should I hang
no, I
tight? You
mean,
tell
we
me.
probably have another at least 30 minutes, at least.
I can email you. Let me,
Okay.
I mean, she's here now. There's no sense in delaying the inevitable.
I don't want to.
Right.
And I don't want to. I'm looking to get a resolution.
Okay.
But
I'll hang tight.
I
I'll
need to
just wait
decide
for
what
you.
our
Andrea,
position.
Andrea, at some point, there's got to be accountability.
I get
And when
it.
you come back here and you sign up the day before and you do the wrong thing yet again, it's,
I don't disagree with you, Judge. I get where you're coming from. I get where he's coming from. I'm just trying
we
to,
also appreciate your zealous advocation, right? Because I get it.
Getting me anywhere, but
Well, I think you're doing
I'm just-
quite
I'm
well.
joking.
But Andrea, 2 years later, you're still in it. There's a lot to say for that, right?
That's exactly what, and this,
At some point, we got to cut the cord. Let me know.
Okay.
give me 5 minutes.
Okay,
Give me a call. I'll be right back.
thank you.
Yeah, sure. Probation department either feels she's reached a point where they can no longer help her and she needs a higher level of care than the probation department can give her. Or B, if the probation department feels that they can still treat her, we follow the recommendation of the probation department, B being Texas.
And they requested a 6-month extension, but her last been on 7 months.
But Judge, if she registered for the classes, there will be completed in 6 months.
I'm not doing a 6-month reset for her to do one class a
We
week.
can bring her to court. We can bring her to court for status updates. I'm 100% on board with that. I think that that's actually a very good idea. But what I'm saying is that the probation department feels that she could be helped with the IOP and SOP. That's my understanding. Please correct me if I'm saying something wrong. My understanding is that probation department feels that they could help her with the IOP SOP. I think that to her defense, nobody told her she needs to register, at least as far as I'm aware, 2 to 3 times a week. So
I told her last time we were here.
now when we approached, because I was with her,
Yes,
Judge.
I told
No, I
her.
was with her and I don't remember you saying that.
I told her what you need to have done, and then this is what you register for. When you come back, this is what we're gonna end up doing. Regardless, look, regardless.
What I'm saying is, since the probation department feels that they can help her, if she can register to one of the 3, and I'm gonna bring her up here with, if you decide to allow her to continue, I'm gonna bring her up here and we all talk, so everybody's on the same page. If she does it within like a week, not a month like we did last time.
I'm not ever going to reset her for over 2 weeks at a time
And that's
because I
fine.
can't trust anything to happen.
And that's fine.
And Mr. Lindsay, unfortunately, the way it works is that it's unfortunately, like a little child. They push and they push and they push. And it's truly, it's childesque because they push and they push to see how much they can get away with. And as evidenced here, you sign up the day before court.
This is all predicated on if the court does not rescind its order for supervision.
What I'm going to do now is I'm going to reset her for 1 week. She has 1 week to sign up for the 3-time-a-week course. She needs to come back, show us that she's done that. And then after that, I'm going to set her off 2 weeks. Every single 2
Can I bring her up
weeks.
here? So
Sure.
This is the turning point. The judge lays out a new, micromanaged schedule, 1 week to register for the proper program, then bi-weekly court check-ins. This is no longer about trust, it's about surveillance. The court is essentially saying, we can't rely on you to self-correct, so we'll watch every step. In practice, this is exhausting for everyone involved, the judge, the probation department, and yes, the defendant. But when a case drags on for years, and compliance is spotty, this is sometimes the only path short of termination.
I want her to be part of the conversation, so if she comes back and she doesn't do, so nobody can, so there's no possibility of saying,
I'm so over this, it's just ridiculous. Come up, Ms. Ramirez. So I will indefinitely set this case off 2 weeks at a time to make sure that it gets done. Because I can't do 4-week resets anymore, unfortunately. So we are now going to have to micromanage just I don't think that this is right. And I don't think that
The judge's words here cut deep. It spits in the face of every single person who does a good job with this program. This is more than frustration, it's a moral rebuke. Programs like PTI are designed for people who want a second chance. When someone appears to game the system, it insults not just the court, but every participant who struggles daily to comply. This is where public perception and courtroom reality intersect, because the audience is now asking, is Carol a victim of bad communication, or is she exactly the type of participant the judge warns about?
I don't think that this is fair because it really spits in the face of every single person who does a good job with this program. And what you're doing now is not what this program is designed to do. And it really violates the spirit, because this is a program that's supposed to teach you right and wrong, teach you how to act in the free world, and you've done everything against that. I mean, for you to sign up for the class one day before court, it's just, it hurts. And it's shameful. Because when I told you, last time you were here, I told you that I wanted you to sign up immediately after you were done. And you sat there and you waited. Not 1 week, not 2 weeks, not 3 weeks, 4 weeks.
Oh, person's calling back.
So now you've shown me that I can't do long resets on your case. So if you fail one more time, if you ever fail to attend a meeting, if you ever fail to whatever you need to do, you will be out of this program. I will not do this again, and I will immediately set your case for trial. You have 1 week to sign up for the class. That's 3 times a week. And thereafter, you will get 2-week resets every single time to show me that you have attended this class 3 times a week. If you fail to go one of those times in a week, because it's the class is designed for you to go 3 times a week, every week. And if you fail to do that, that's it. Do you understand?
Yes, sir.
Judge, just to make sure we're all on the same page. Judge is asking you to go back to that list that you have and find a place that offers the program 3 times, IOP 3 times a week. What are the requirements? Is SOP once a week or,
But she
okay,
has to complete IOP first.
right. So you have to go back to the list, find a place to register for IOP that does it, that meets 3 times a week. You do IOP, and once you're done with IOP, you find SOP that meets once a week. And you have to
90
have,
days. Okay.
right, and you have to be registered in the IOP that meets 3 times a week by next court setting, which will be in about a week.
Not about
In a
exactly a week
Okay,
from
do I
today,
have it
next
correct?
Wednesday.
Do I have it correct, Judge? Right, okay, so do you understand that?
Yes.
There's not gonna be another chance. Okay.
State has nothing further, Judge, for the court.
See you in a week.
Thank you, Judge.
And there it is, the judge's ultimatum: comply fully within 1 week, or the program ends, and trial begins. This is Carol's last, slim chance to prove she can follow through. The stakes couldn't be higher: continued probation versus a criminal trial that could end in a conviction and jail time. For you watching, what do you think? Is this a fair final warning, or has the court already decided her fate? Drop your verdict in the comments. And if this case had you on edge like it did us, hit that like button, share it, and subscribe for more courtroom breakdowns every week.